I'm Jora Trang. I'm the Chief of Staff and Equity at Worksafe. We have today with me Garin and the closed captioner Christina. So welcome to our third training. Today we'll be talking about strategizing with workers and engaging state agency.
Sure.
Is that the closed captioner? Okay.
Yes, go ahead again.
Okay. All right. So you all are seeing my screen here. So I will be handling the slides today. So this webinar is being recorded. This is to ensure accessibility. I will be speaking slowly. You've all been muted. This is so that folks who need closed captioning can follow along. So I believe if you click onto the bottom of your screen, there should be an option to allow you to see closed captioning. Later on this, we are recording, so later on this will also be available. And so closed captioning is also available in the recording. If you have any comments, use the chat function. So that function also you can click on at the bottom. If you are requesting MCLE, you're required to give a survey at the very end. But we hope that you all give a survey and evaluation on this seminar so that we can continue to optimize our trainings. Just so you know, we will have a chat activity later on towards the end of this training. This is a very dense training with a lot of information, so we'll try our best to go through all of it. During the chat activity, we'll be asking you to chat on the side to make sure you have your case study in front of you and the chat function or chat window open. So Ganene's going to tell you a little bit about evaluation. Ganene?
When you exit the Zoom, your browser will open up a tab that looks like this photo below. Select continue to fill out the brief evaluation. We encourage feedback from everyone, but require it from those seeking MCLE credit.
Yeah, so please do that towards the end. So once again, you are joining our third lunch seminar. We have 4 more to go, so please join us for those as well. They are every Thursday at noon. Again, I'm the Chief of Staff and Equity. My pronouns are they, them, their, she, hers. And I'll let Garin introduce herself.
Hi, I'm Kadeen Umphrey, pronouns she, her. I am a staff attorney at Worksafe.
And Garin is the amazing person who coordinated this entire seminar. So Worksafe is a nonprofit, statewide nonprofit, and we are dedicated to preventing worker illness, injury, and death. We do this by increasing worker power, supporting more protective laws and regulations and standards, and working directly with worker advocates and legal aid centers to build their capacity to represent clients with occupational safety and health issues. So occupational safety and health has an acronym, it's OSH. So you might hear me referring to OSH every now and then. I'll also be referring to employer as ER and employee as EE from time to time, or you might see that in the slide, just so you know. You can visit our website. We have numerous resources and supports on our website. And also if you wanted to request more trainings, you can do that through the website as well. So today our goal is to provide you with even more tools to conduct your client intakes on OSH issues and COVID-19 related issues. The past 2 seminars we've given tools, and so we're giving more tools today. And again, we'll give you more relevant OSH standards. We'll give you the basics of how to file a Cal-OSHA complaint as well and how to prep for that. So this is a quick overview of our agenda for today. We're gonna go through kind of what we covered in the last trainings in case you didn't show up for those. It's really quick. So it might, some of it might be very complex, and we encourage you to go back and review the prior trainings once they're available. We'll also be talking about the control of harmful exposure, personal protective equipment, anti-retaliation, and record-keeping standards. We'll tell you how to file a Cal-OSHA complaint and what you need to do before and after. And then we'll just give you some basic information on how to file an OSHA retaliation complaint. We have a case study that you have been sent, so we'll be referring to it throughout the training. And if we have time, we're going to go into confidentiality issues with respect to COVID-19 and what to look out for in the case of reopenings. So now I'm going to
Jora, real quick.
Yeah, sure.
Before we get started, I do want to launch a poll just to see who we have here today.
Okay.
As I just got it started, it should pop up on your screen. I'll give people a couple seconds. Thank you. This is to see we are gearing our trainings. Okay, I will end it in a couple of seconds to get a few more votes in. Okay, so we have a lot of worker advocates here and some attorneys, welcome, and a few others. And the other question we want to ask is, we'd like to know what you have the most experience in related to the topics we will discuss today. Feel free to choose more than one. It should pop up on your screen, the poll. I will give a couple more seconds before I close the poll to get a few more votes in. People want to select an option. So we have people with a lot of organizing and worker advocacy experience, employment law experience, and some people are here to learn. Okay, thank you. Go ahead, Jora.
Thank you. So I'm going to do a really quick overview. In the past trainings, we talked about the 6 different categories of workplace hazards. These include green here, the chemical. Let me see. Chemical refers to hazardous substances that might be found in the workplace, such as disinfectants, gases, mists, vapors. We have safety and mechanical. These are hazards that create unsafe working conditions like slips and falls, tripping hazards, moving equipment or parts, or machinery that isn't properly guardrailed. We have ergonomic design, that is physical factors that can result in musculoskeletal injuries, such as repetitive motion injuries, awkward and static positions, and forceful motions, pushing and pulling. We also have physical hazards. These are environmental hazards that can harm an employee without necessarily touching them. It includes heights, noise, radiation, pressure. And we have what everybody has been experiencing with the pandemic, which is infectious and biological hazards, mold, virus, bacteria, bloodborne pathogens. Sometimes you can find this in the retail setting because employees are made to kind of pin those security devices on clothing, for example. It has a pin in it. And finally, we have work, organizational, psychosocial, and this involves situations that can affect the mental and emotional health of an employee. It can involve workplace harassment, sexual harassment, coworker tension, workload, work pace, and intensity, how much work you have to do, and the tiny amount of time that you're able to do it. And the reason why we put it in the center is it affects every other thing. In order to find out what kind of hazards workers may be experiencing, we talked about doing a body map right here. And we also talked about having workers draw out the physical map of where they are experiencing issues in the workplace. We talked about a hierarchy of control in terms of what employers should be doing to correct the hazards in the workplace. Elimination or the top of this is the best, and that's what many of us are doing, social distancing, isolating yourself in your home. The worst and least protective is personal protective equipment. This is like the mask and the gloves. Another way to depict this is what we like to call the bullseye. It kind of gives a better it's a better visual, I think, because everybody knows they want to target the bullseye, which is elimination. What everyone has been fighting about in the workplace is PPE, which is personal protective equipment, the eye protection, masks, and gloves. Other levels are administrative control. This is like staggering schedule, limiting the amount of people, widening the aisles so that you have less contact between, or 6 feet or more of distancing. Engineering controls include things like having good ventilation, sanitation, plastic face shields, and doing a lot more sanitizing. Substitution is virtual substitutions for in-person activities. That's the remote working environment. And I'm going to turn it over to Karin to talk about employee rights.
So employees have the right to know, for example, the right to know what chemical to use or about that chemical that they're using when disinfecting. The right to protection, as Jora just mentioned in the slide before, it's much more than PPE, and the right to take action, which is the right to file a OSHA complaint based on the previously mentioned rights. Next slide, please. So I just want to review the case study I sent out last night. If people did not have time to review it, I'm going to cover it now as we'll be referring to it throughout the training. Sam, pronouns she, her, hers, has diabetes. She works at Bark Warehouse moving product. Bark is an essential service. Bark did not implement recommended safety protocols until they got bad press. They started doing temperature and symptom checks and providing cloth gloves to workers, but did not change their sanitation procedures. Bark requires workers to put their names on the gloves and wear them every day at all times and reuse them every day. Bark rarely launders the gloves. The gloves don't fit everyone, and some workers take them off to handle products. Bark does not enforce its glove rule. Next slide, please.
Whoops, sorry.
So Sam is only given one disinfectant wipe to sanitize her station at the beginning of work. There are no cleaning supplies available during her shift, and the shared hand sanitizer is often empty. Sam is told to wash her hands frequently, but the nearest washroom is on another floor, and her breaks are not long enough to allow her to go wash her hands and come back. The layout of the warehouse makes it impossible to stay 6 feet from people, and Bark has done nothing to change the workflow to allow for distancing. There are rumors that several workers have tested positive for COVID-19. Sam asks a coworker, Juan, to join her to demand that her supervisor tell them who tested positive. They also demand more clarity on Bark safety protocols and training for workers on best practices to prevent spread. Her supervisor refuses to give her any information or budge on her demands. Sam files a complaint with OSHA. A week later, her hours are cut. 2 weeks later, she tests positive for COVID-19. She reports it as a work-related illness a week later and requests medical leave. She is fired. So I wanted to do a quick recap of standards we covered last week in case people were not on that training. As a quick overview, the IIPP is a very important standard. It is the most highly cited standards that employers violate. For example, in the case study with Sam, Bark has violated the IIPP because Bark has failed to assess the workplace for COVID-19 hazards. If the employer had done so, they would not have failed to close off areas with COVID-19 positive employees, also failed to restructure the workplace for 6-foot physical distancing, and failed to provide proper controls, including effective PPE. Additionally, the IIPP requires training. Sam and Juan asked for a training and were not given the training that is already required by the IIPP. Finally, there needs to be a system for communicating with employees about issues involving COVID-19, such as policy and procedures being followed and incidents of exposure to COVID-19. Employees need to be able to report and discuss issues without being retaliated against for speaking up, and as we see, Sam was likely retaliated against. For sanitation, washing facility standards, Bark is in violation of that because workers are not provided with proper cleaning or sanitizing supplies during their shift. Also, commonly touched surfaces do not get cleaned often. There is likely a problem with the bathroom being on a different floor, and the hand sanitizer at the bathroom is often empty. Finally, for the hazard communication standards, which is the right to have information and training about workplace chemicals and hazards, Sam and Juan have the right to know about the chemicals that are used in the disinfectants they were given to sanitize their equipment at the start of their shift. There is no information in the fact pattern that says whether these cleaning supplies have labels, which they must. Next slide, please. Turn it over to you, Jora.
Okay, great. So we're going to talk today about the California Occupational Safety and Health Act, which was passed in 1973. What it did was set up the Department of Industrial Relations, which administers the California Division of Occupational Safety and Health. We often call that DOSH, but you all probably have heard of it as Cal OSHA. So Cal OSHA is responsible for protecting the health and safety of workers and for making sure that employers follow OSHA regulations to keep the workplace safe. So almost all workers are covered under Cal OSHA, including public employees and undocumented workers, but there are several types of workers that are not. This includes independent contractors, federal employees, domestic workers and day laborers, and family members of farm owners who work on the family farm. If there is a family farm that hires farm workers who are not family members, those non-family member workers are covered under Cal OSHA. So there are three general branches of Cal OSHA, the Cal OSHA system, just like in the government. We have the enforcement, which is the state agency that we're most engaged with at this time. That's Cal OSHA or DOSH. And so they're responsible for enforcing health and safety laws. They usually do that through receiving complaints and then going out with inspectors and or doing a letter inspection and possibly citing a place or requesting change to comply with laws. And then if there are issues with that, their attorneys then are engaged in the judicial process. So the secondary branch is the legislative branch, the Occupational Safety and Health Standards Board. They are responsible for adopting, amending, and repealing OSHA standards. And the Judicial Board reviews appeals. So in the first case, if Cal OSHA were to go out and issue a citation against an employer, and the employer doesn't agree with a citation, they can then appeal it. When they appeal it, it goes to the Judicial Branch, which we call the Appeals Board. And in that case, that's when DOSH attorneys show up and defend Cal OSHA's citations. That is where worker advocates, unions, and workers can participate in the appeals process as a third party. And that's an entirely different training, which we'd love to give. It's not part of our series, but if you're interested in it, please let us know. We'd love to also give you information on that. So Cal OSHA, generally the Standards Board is responsible for setting up standards. However, Cal OSHA also issues industry guidances, which you all have become familiar with because Cal OSHA issued the general industry guideline for COVID-19, which some of the guidelines of which are listed here, encouraging employees who are sick to stay home, social distancing, flexible work sites, canceling large work meetings, and etc. They've also set up a whole bunch of related guidances, which you can find on their website. This lists some of them, and I think they're continuing to work on them. The one that we have sent you by email last night is the logistics and warehousing, because that relates to the BARC warehouse case study today. But there are so many more, so please refer to these, as long as as well as the CDC, and Department of Public Health for further guidances for specific workplaces. So I'm just going to list some of the things that is in the logistics and warehouse guidance that you received by email. One is to provide appropriate PPE, personal protective equipment, and to engage in the proper use of face coverings. There's a special note for accommodating those that can't wear face coverings, making sure there's a face shield with a drape at the bottom as an example. All employers should have an updated IEPP that involves or includes COVID-19, basically some kind of safety plan on how to address, identify, and fix issues that come up with COVID-19 or coronavirus exposure in the workplace. This includes needing to train and communicate with workers, including provisions for frequent hand washing, physical distancing, heightened sanitizing, and also temperature and symptom screening of workers as they come in. And if workers are testing positive, then some type of contact tracing. So let's talk about how to file a health and safety complaint. So before you file a Cal OSHA health and safety complaint, there's a couple of steps that we want to make sure you engage in to make sure that you have the most strongest complaint possible. The first is that in the filing of a complaint, you want to make sure that you're engaging in strengthening workers' voices and empowering workers. So you want to gather workers, get as many testimonials and a picture of the workplace, get as complete a picture of the workplace as possible with as many workers as possible, so that you can kind of get a good overview of what's going on in the entire workplace. And you can also get a sense of which workers are comfortable with having their voices heard during this process, serving as witnesses and providing testimony if the citations that are issued end up being appealed, and providing statements to a Cal OSHA investigator. Where possible, you want to try to mobilize workers to engage in complaint process or identifying workplace hazards together in the workplace, because you want to engage concerted activity and protection under the National Labor Relations Act, basically. So the more workers can act together, two or more, the better. You also want to have workers document and gather as much information as possible about what's going on in the workplace. If there's anything that can be documented in terms of even their personal, not personal, but note-taking that relates to workplace issues that is separated from personal journaling and diaries, so just a personal, a personally kept notebook on workplace issues that are coming up, and or any kind of documentation that's coming from the workplace. Some workers ask us if they can take pictures, and Cal OSHA does accept pictures as evidence. Just make sure that the workers are aware of what the employer's policies are around taking pictures in the workplace, and be careful about that. So you also want to build a relationship with Cal OSHA. We try to set up meetings with the district manager before we file a complaint, so we can kind of make them abreast them about what's going on in the particular work site, and kind of get their opinion and their expertise on what they think would be the best to include in the complaint. This can be rather difficult in the current environment because, as you know, Cal OSHA is facing a lot of complaints around COVID-19. However, I would still encourage folks to try to engage with a district manager if possible. Oftentimes, worker groups use the possibility of filing a Cal OSHA complaint as leverage to demand for changes in the workplace. This is because most employers don't want Cal OSHA in the work site. Cal OSHA is one of the only state agencies that kind of just show up unannounced and do an inspection of a work site. And so they're not too popular with employers. And so the threat or employers are concerned about the threat of Cal OSHA showing up. So it's all, you can also use that as leverage in a demand letter, for example. You want to draft a broad complaint that ensures what is called a wall-to-wall inspection. So if you draft a complaint that's very narrow, Cal OSHA might come in and just deal with that very narrow worksite area or worksite issue. So the more things that you can put into a complaint, the better. That's why you want to engage as many workers as possible. We're going to talk a little bit more about how to do that. So I wanted to give you the inspection priority list for Cal OSHA so that you can understand how best to engage Cal OSHA. If you want a wall-to-wall inspection, or you want Cal OSHA to come out and do a physical inspection, you want to ensure that you capture things in your complaint that will force Cal OSHA to engage quicker with you. So if there is an imminent hazard, and I'm going to define all these in the next slide. So just for right now, I want to set up the kind of the timeline requirement. So if there's an imminent hazard, Cal OSHA is required to come out immediately or as soon as possible to do an inspection, a physical inspection. If it's a formal complaint alleging serious hazards, Cal OSHA will come out in 3 business days of receiving the complaint. If it's a formal complaint with non-serious hazards, Cal OSHA will come out in 14 calendar days. And if it's a non-formal complaint alleging serious hazards, they'll come out in 14 days. They will do 14 days by phone. If it's non-formal, non-serious, they'll do a letter investigation. So obviously, you want Cal OSHA, most of us want Cal OSHA to come and do a physical inspection. So what is the difference between formal and non-formal and serious and non-serious? So let's talk about that. So an imminent hazard is a hazard that can cause death or serious physical harm immediately or before the hazard can be eliminated. Complaints are considered to be formal or non-formal depending on whether or not an employee's name is provided. So even if an employee representative comes in and gives their name, like say I'm Acme Worker Advocacy Group and I'm representing these anonymous complaints, the complaint is still non-formal and therefore falls under the 14-day, priority level. So if an employee is or employees are able to step up and give their name, the better. And Cal OSHA does ensure the complete confidentiality of that employee in the complaint filing process. There's no guarantee that an employer can't then, by process of deduction, identify, by guessing who that employee may be. But nevertheless, we always advise groups, when possible, to name an employee because it is a confidential process. And if that employee is retaliated against, there is at least evidence that the employee did something, took an action, and then received some kind of retaliation process because they were named in the complaint. So the difference between serious and non-serious hazard is whether or not there's a substantial probability of death or serious physical harm. So when, I'm going to talk about some basics now. When should you file? You should file as soon as possible, but within 1 month. The sooner the better, because you don't want information to get stale. You want Cal OSHA to be able to come out as soon as possible if there is an issue in the workplace. We also could provide trainings on what happens once Cal OSHA comes out and does an inspection, because there's a whole bunch of issues with that process as well. But for the purposes of this training, you want to file within 1 month if possible. You want to identify, again, a worker, even if that worker has identified someone else to be their employee rep, you at least want to identify a worker by name. You want to describe the events and what happened. And I like to think of it as if you're shooting a film. If you're shooting a film, just think of how you would pan the entire workspace. You want to take into account temperature, the time of day, all details that you can think of, who's there, the actors, the players, so be as complete as possible. And about the workplace hazards and the logistics of the workplace, the employees present. I skip a slide. You want to describe the injuries or illnesses that is happening, list any health and safety violations. If you know it's not a requirement that you list the law, but if you happen to know, that's a plus. And also talk about whether or not the employer knew about the hazard. Furthermore, somebody does not have to get hurt in order for you to file a complaint. Exposure is sufficient. So this is so important because you want to be able to identify hazards before anyone gets hurt. And a complaint can be filed online. It can be very in-depth, like the one we're going to show you is extremely in-depth, multiple pages, citations to law. But it can be very simple as just picking up the phone and calling Cal OSHA. For example, one day I was driving down the street. I passed a construction site and I saw some construction workers who were standing outside on a scaffold without fall protection. It was way above 20 feet. And I just picked up the phone, my cell phone, and I have Cal OSHA on speed dial. And I just called Cal OSHA and said, hey, this is what's happening here. And the next day I saw, or at least a week later, I saw folks with fall protection. So I don't know if it had to do anything with me or not, but that's just to tell you the importance of health and safety to Cal OSHA. Even bypassers can call them and report. So after submitting the complaint, it's so important to stay on top of Cal OSHA. You want to be friendly and diplomatic, but you want to build a relationship with the inspector who is going to be handling the case, and the district manager if possible. The more of a relationship you build, the better, because you're always considered a third party. The two major parties in any Cal OSHA case is Cal OSHA, the state agency, and the employer. And so you're kind of like this third party that that filed the complaint. And oftentimes Cal OSHA might, they're going straight to the employer for all kinds of information. They may come back to you for information, but sometimes we're kept out of the process as third parties. And so we want to stay on top of it as much as possible. You want Cal OSHA to inform you of every step of the way. You want to make sure that they involve you in any kind of informal conferences or meetings with the employer if possible. You also want to request a complete copy of the complaint file if possible. So again, we have a more intense training on how to actually go through the process of a complaint and then the appeals that happen. So we're not going to be covering that today. So we're going to cover 4 specific standards in this training, and I'm going to hand it over to Karin to do the first one.
Okay, control of harmful exposures is a standard where the employers must protect employees from inhalation exposures that can result in injury, illness, disease, impairment, or loss of function. This is limited to dust, fumes, vapors, and mists, those types of harmful exposures. And employers must implement engineering controls where feasible and administrative controls where practicable, or provide respiratory protection, which again is the least effective if the engineering and administrative controls are not enough to protect employees. This will be important with cleaning buildings that have not been cleaned or maintained during coronavirus. Lots of dust buildup or use of chemicals that create vapors or mist when cleaning would fall into this standard. Next slide, please.
Okay, thank you, Karin.
Go
So you
ahead.
probably have all been focused on personal protective equipment. This has been a big deal with the coronavirus, and it's been a huge topic of debate and concern. So I wanted to kind of give you a basic overview of personal protective equipment requirement, knowing, of course, that once again, it is the least protective level. So under Labor Code Section 6401 and 6403, all employers must provide and use safety devices and safeguards so that they can reasonably and necessarily protect the life, safety, and health of all employees. This means that they must provide and pay as well. The seminal case for that is Bendix Forest Products Corporation, which you received by email. We get a lot of calls now, over time, where employers are providing PPE, but they're charging it somehow to the employee by deducting their wages, minimum cost that goes out of their wages. We get that a lot with steel-toed boots, because they're worth, maybe $100 or so, and so they might start docking the employee. That is not appropriate under Bendix. Okay. So in the process of identifying what PPE is required, the employer should be engaging in a hazard assessment to evaluate the workplace for what is the best PPE. In this case, with COVID-19, they should be looking at how is exposure happening and what's the best way to protect workers. Again, along this lines of starting here with this being the least. We had, for example, a case study in the last training where the employer was a retail grocery store, and one measure of engineering control that they used was to place, maybe they didn't use it in our case study, but they didn't use it, but the worker noted that other grocery stores had that, the plastic shield that you've been seeing when you go into grocery stores nowadays. That is a engineering control. An administrative control that has been used in retail grocery stores is that when you go in now, there's these little stickers on the floor that says 6 feet, apart. And so you have to stand 6 feet apart from the other person who is also trying to buy groceries. So that's an example of administrative controls. So in the BARC example, administrative controls might be, instead of having a warehouse where all the aisles are densely compacted together and all workers are having to, basically stand less than 6 feet from each other, aisles can be lengthened or widened, and workspaces and workstations can be lengthened or widened so that there's more distance between people. The employer has to make sure that the PPE is of design, fit, and durability to protect against hazards. In this case, in BARC, they are providing cloth gloves. And it's noted that some employees can't quite use the glove and handle the product at the same time, so they're taking it off, which is increasing exposure. Also, there's not hand sanitizers for employees to clean their hands while they're taking their gloves off. I think there was also a point that the gloves might get moist, which is an issue. So if employer has given you a worker's gloves and they can't use the gloves properly to do their work, it's a health and safety hazard. If first of all, in this case, they're potentially increasing exposure to COVID-19, but they also may be increasing their own exposure to other hazards, such as maybe their gloves might get caught on equipment or something. If it's too big, if it's too tight, then maybe it's causing some kind of discomfort to them. And so those are things employer needs to be mindful of. They also have to provide training. This is something that we're hearing a lot, is that employees are getting personal protective equipment and they're told to do this and that, just like in this BARC warehouse example, but they're not given any kind of training on the best practices or the best ways to limit exposure in their workplace. The training also has to include information on the limitation of the PPE. In this case, BARC is given cloth gloves, and they're probably representing the cloth gloves to be excellent, but they also have to tell workers, well, it's not excellent in these cases. This is what might happen, so you have to make sure that you prevent these kind of things from happening. For example, the gloves getting wet, or taking the gloves off when you're handling product. They also have to have some way of properly caring, maintaining the gloves. BARC is not engaging in any kind of regular process of sanitizing the gloves. The case study says that they're only doing it rarely. They're making employees put their names on the gloves, probably in some kind of black Sharpie. But then what happens at the end of the day? Where do the employees put the gloves? Do they just kind of throw them down somewhere in some kind of like communal work area? And is that the best way to ensure lack of or to limit exposure? The employer, sorry, this should be employer. Each employer has to demonstrate an understanding. Wait, that's right. No, each employee has to demonstrate an understanding of the training, and often the employer does this by certifying that the employee has received and understand the training. And oftentimes what we see when we do complaints is that the employer has made an employee watch a 7-minute video on something like how to drive a forklift, something that requires much more than 7 minutes to understand. And then they've made them sign a little document, and perhaps the video was all in English, but the workers spoke another language. So that is a failure to actually provide, demonstrate that each of those workers who were at that training understood it, because it wasn't in a language that they understood, and that it was sufficient. A 7-minute video on the operation of a forklift is not sufficient, so you want to really ask workers when you talk to them, explain to me exactly what happened during the training, how long was it, how intense was it, who did it, who gave it. And I'll let Gani talk about anti-retaliation.
So we'll cover anti-retaliation briefly today. The Labor Code makes it illegal to retaliate against a worker, an employer to retaliate against a worker for exercising their health and safety rights, or to fire a worker for refusing to work in an unsafe work environment, or to retaliate against a worker for disclosing information about the employer's working conditions. Next slide, please. So these are some examples of retaliation. For example, giving workers less desirable duties or cutting hours, laying off or firing the worker, harassing workers, transferring workers maybe from one shift to another shift or from one department to another department. Continue. Next slide. In addition, immigration reform resulted in legislation that protects workers who experience immigration-based retaliation. So the Labor Code now prohibits the employer from reporting or threatening to report a worker or their family's immigration status, reporting or threatening to report a person's immigration status to take workers' property, or requesting more or different documents from a worker than is required under federal law. Next slide, please. For example, this could be, using E-Verify illegally. That's laid out in Labor Code Section 1109. Threatening to file a false police report. Also, attorneys cannot report witnesses, parties, or their family members to immigration. If an attorney were to engage in unprofessional behavior, on the State Bar website, you can report that attorney with their name, and the State Bar will investigate and discipline that attorney. And also prevent whistleblowing. Employers cannot prevent whistleblowing activities either.
So what if there is retaliation in the workplace? We want you to make sure that you leverage union and worker power in trying to document and engage and address retaliation. And it's also very important for you to understand that retaliation is not covered by Cal OSHA. So this can be very tricky because you might be, have created this amazing relationship with a Cal OSHA inspector, but then the worker gets fired. All you could do is tell Cal OSHA, but then there's nothing they could do about it, okay? So the labor commissioner is the proper agency to file a retaliation complaint with. Ideally, Cal OSHA should be talking to the labor commissioner and cross-referencing the case, but don't rely on that. Actually go and file the complaint with the labor commissioner. If there was a concerted activity, more than one employee engaged in the action, then it would also fall under the National Labor Relations Act. Deadlines are 1 month for Fed OSHA. You can file under Fed OSHA as well, under 11C, although sometimes they might refer you right back to the DLSE or the labor commissioner. Under DLSE and NRLA, that is 6 months. There's no exhaustion of administrative remedies, so you can go ahead and file in civil court if you wanted to. So all of these instructions are on the various websites for the state agencies. Now I'm gonna jump real quick into record keeping. In general, employers are supposed to keep records of injury, illnesses, and fatalities, and this also applies to COVID-19 related illnesses. And so employers are required to report if COVID-19 resulted in death, days away from work, restricted work or transfer to another job, medical treatment beyond first aid, a loss of consciousness, or significant injury or illness. So if a worker tested positive for COVID-19, but then had to take days in quarantine, this doesn't count as days away from work. So we're just at the beginning process of this. So we don't know yet which COVID-19 cases are not getting reported, if it doesn't result from days away from work. So it's still yet to be seen. However, Cal OSHA and the CDC have said to have advised employers to go ahead and report if somebody has COVID-19, even if they become sick at work and the employer doesn't know for sure whether or not they contracted COVID-19 from the workplace. You don't have to have a positive test in order to report a suspected illness is sufficient. If in the case of a serious illness, there's an additional requirement that the employer must report within 8 hours if a serious illness involving inpatient hospitalization for other than medical observation or diagnostic testing is triggered as well. So two different types of reporting there. So employees have the right to request an incident report And if they do so, they are supposed to be provided of it by the end of the next day. If you are a worker rep or a union, you may also request incident reports, which the employer is mandated to give you within 7 days with all employee information redacted, and they're supposed to give it to you free of charge. And the reason why I'm telling you this is kind of important for those of you who are representing clients in a workspace where you kind of feel like maybe reporting is not occurring the way that it should. You can request to see how diligent the employer is doing reporting. And reporting is so important because reporting is a way for public health officials and agencies to figure out what injuries and illnesses are occurring to workers and to figure out how best to prevent those in the future. So record keeping sounds kind of dull. It's about keeping a record, but it's actually just so important to ensure that we know we have the correct information that we need to prevent illnesses and injuries in the future. There's also electronic reporting requirements for employers that have more than 250 employees, or if they have 20 to 249 employees, but they're in specified industries. So those employers who engage in electronic reporting, you should be able to find their reports online, or at least OSHA should have access to those that information.
So immigration status is irrelevant. Immigration status of a worker, and inquiry throughout the complaint process is prohibited. So once that name is on, the name of the worker is on the complaint, up to if CalOSHA did give a citation, if that citation was appealed all the way to the California Supreme Court, at any time in this process, inquiry about immigration status is prohibited and would not be a question that could be allowed of that worker.
So right now we're going to do a complaint review. So I want you to be able to use the chat and review the case study that we've given you and see if you can categorize any violations that you can see through the chat. And I can't see your chat, so Gadine's going to help me out. See if you can identify which ones, if any, are imminent hazards, if there's any serious injuries or possible serious violations or willful violations. And we're going to give folks just a couple minutes to do that. Just take your best guess in the chat.
And I do see some questions in the chat. One of them we're going to get to after this activity is over, related to the log 300s and HIPAA. We're going to cover that after this complaint review. And then at the Q&A, if we have time at the end, we can answer other people's questions. And in the Q&A, if you go to the answered portion, there is an answer to a question there about the complaint being filed in 1 month. Any questions that we don't get to today, we will email you so that your questions are answered.
All right, so do we have any kind of takers for identifying possible violations?
Not yet.
It's hard. It can be hard.
Oh wait, let's see. So somebody says they think that the hazards are willful, serious, and imminent. There's also a wage theft issue because workers aren't being allowed to use the bathroom properly.
Mm-hmm. Mm-hmm.
And so I guess with the bathroom situation, that also, can bring into the standard I talked about a little bit earlier, with sanitation and washing facilities standard. That would also pull into that health and safety standard as well, beyond just wage theft.
Okay, well, I'm just going to jump ahead and share this with you because we're running late on time. So I want to be able to cover some of your questions. So this is an example of a sample complaint that we'll send out to you. And the reasons why we had those particular issues that we asked is that we want you to be able to elevate your complaint to the highest level possible. And the best way to do that is by identifying imminent hazard. And here you can see in our complaint, that we are arguing that exposure to COVID-19 can definitely cause imminent hazard, because a worker, you don't know how a worker will respond to being infected with coronavirus. They can be asymptomatic, or they can end up with respiratory illness and death. And so that in and of itself is an imminent hazard, because it holds this threat that anybody who becomes exposed could, they could result in their death. So our complaint here is crazy, multiple pages and super dense, like 6 pages long. Again, like I said before, you can just call Cal OSHA and report. But if, to the extent that you can provide a complaint that is as extensive as this, we encourage you to, and we will provide you with the language and the sample complaint to do so. So this complaint goes through, for example, I'll just give one example. Let's jump to inadequately implemented administrative controls to maintain physical distancing. And so the warehouse keeps saying, hey, you guys got to work 6 feet from each other, but it makes no way for workers to do that, such as creating wider aisles and whatnot, changing the way break rooms are, staggering shifts, having less workers in one particular area. I also kind of go into PPE here and what they're not doing correctly, that does not maintain the glove in a sanitary manner, et cetera, et cetera. So we'll be happy to share that with you all after the training. So let me see if this is going to be a smooth transition or not. Come on. Okay, well. Okay, y'all can see that, right, Karine?
Nope, I can just see the Cal OSHA complaint.
Okay, hold on. All right, so next I'm going to talk about, okay, share, present. Technical difficulties are always so much fun. In the last 10 minutes, I'm going to try to go through some of the questions that have been raised about confidentiality. Let's see, record keeping, all right. Whoops. So at the very end of your case study, there was a request by Sam to know exactly who was infected. Some workers are demanding to know, well, I want to know if it was the person that I worked next to yesterday. I want to know if I'm at risk. And we want to give you some basic information around confidentiality and notice. So the California Department of Public Health, CDPH for short, has issued a guidance that all employees who were potentially exposed should be notified that they were potentially exposed. However, the employer must maintain the confidentiality of employees with a suspected or confirmed COVID-19. The employer must share that same information with the local Department of Health and conduct contact tracing. However, they cannot share that particular employee's name to other employees. So yes, share with Department of Health. No, don't share with other coworkers. And this, I'm just going to cite a couple of laws that protect workers. So the American with Disabilities Act protects applicants and employees from disability discrimination. Specifically, it prohibits employers from disclosing the name of any employee with a disease. Whoops, why did that happen?
Because we can't see the PowerPoint, so I'm going to share it for everybody.
Okay, sorry.
Continue.
All right, the American Disabilities Act, and also the California Confidentiality of Medical Information Act also requires that employers continue to maintain confidentiality. So next slide. The one thing that's of interest is that the American with Disabilities Act put a hard stop with antibody tests. And so although the ADA at this point is saying that you can conduct temperature screenings, you can conduct a symptoms testing. Antibody tests would then violate the ADA because it enters into the area of medical examination. Okay, next slide. This is the confidentiality law that I mentioned. There are very few exceptions to this, none of which currently I can see COVID-19 falling under. So employers must keep all information confidential regarding which employees have tested positive. Next slide. There are two other laws that people have been mentioning. I couldn't find a relation of these to COVID-19. The first is the access to employee exposure and medical records. There's a concern that if you're taking temperatures, people's temperatures, that information must be recorded for the employee's duration of the employee's employment plus 30 years. And at this point, I think the understanding is that if the temperature check is done in real time, not by a physician, nurse, or other healthcare professional, this requirement is not triggered. And secondly, HIPAA has been brought up a lot. However, HIPAA, which restricts the use and disclosure of patients' individually identified health information, covers health plans, healthcare clearinghouses, and healthcare providers, which most employment situations don't fall under. And so employment records, even if health related, are not protected under HIPAA. Okay, next slide. And finally, I just wanted to throw in for the last 2 minutes some issues to look at with reopening. We are still kind of lingering between stage 1 and stage 2. We momentarily opened, but then kind of drew back. So that's where we are at right now. So next slide. So if you are starting to see reopenings, we want to ensure that that you're being mindful of any disproportionate impact that any screening procedures may have. They are supposed to be applied in a transparent manner that is applicable to all employees in the same way, and confidentiality must be maintained. So just keep an eye out for that. We also want to make sure that if employers are setting up IIPPs, that they're engaging the workers. Are they making sure that workers have a say? Are the employers in compliance with laws? Do workers have a way to report issues without retaliation? You also want to make sure that employers are providing accommodations for vulnerable workers and properly training workers about COVID-19. Okay, next. Plans for transitioning back to work shouldn't involve just everyone suddenly showing up. It should involve a careful process where the employer has analyzed the potential for exposure in the workplace, which includes taking into account modified work schedules for some employees who are vulnerable, staggering employees, minimizing work travel and third-party meetings, and ensuring that they're incentivizing healthy behavior by encouraging workers to stay home if sick. We are at the hour mark, right, Karine?
We are, and
so shall I close out?
I think if you had captioning on, it's now off. Yes.
Okay.
So I go ahead.
We're just going to close out by thanking everyone for joining us today. We provide case studies, so take your time to review them for the next trainings. And please take the 5 minutes to fill out the evaluation form that's going to pop up after this. Next slide, please. This was a very dense training. We engage in a lot of advocacy work around California workers with multiple coalitions that we convene. If you're interested in any of them, please email me. We're happy to talk to you about that. Next slide.
And also any questions that we didn't get to today, if you have, get to today, we'll follow up by email.
Next slide.
Those are our emails.
There it is. There's our emails. Once again, this training was super dense. This training can be theoretically dragged out to several hours to have more intense information, and we do interactive trainings. We can't do that now in the current COVID-19 environment, but we're happy to engage you all in further trainings. Next slide. So please come and sign up for our other trainings. Anything else, Scotty?
That's it. Thank you. We'll get
Thank
to people's
you.
questions by emails, and we appreciate you coming today. Thank you.
All right. Bye-bye.
Next week, we'll cover the ATD standard and workplace violence.
Thank you very much, everybody.